I'm Robert Capper, I'm part of Harris Rickaby's. I lead the commercial team, and I also lead our Brexit marketing. So it's my role to chair this latest Brexit webinar, which we've entitled "We Need to Talk About Brexit." And yes, we do. And unfortunately, we do. It's happening. It's going to happen. Come what may. 31st December is writ large, and we are less than 3 months to go. So this is the first of two Brexit events this side of Christmas and the New Year. There's a later one in November. This first one, though, we've got 4 speakers. We've got Michael Stokes, who heads our employment and immigration team. He will be looking at the employment issues as we are about to depart the EU. We've then got Nicholas Groffman, who heads our international team. And Nicholas is going to be looking at the opportunities for international trade. Remember that Brexit isn't just a challenge, it's actually an opportunity. We're then going to hear from Kamal Chan, who is a partner in our licensing, regulatory and tax team, and he will talk about health and safety obligations coming out of Brexit. And then finally Georgia Shrine from my commercial team, he will talk about data protection and some of the challenges which will face all of us as a result of Brexit. And then finally we're going to have a Q&A session at the end. If you want to use the chat facility and Q&A facility to put any questions into us, I'll be keeping an eye on those as the programme rolls this morning, and then be picking out a selection of those. If we don't get to any questions, don't worry about it, because we'll actually answer them following up after the webinar, and we'll also make notes available of the answers that we have given on the webinar, so those are all fully available. So first presentation is from Michael Stokes. Michael, as I say, heads our employment and immigration team. Michael's delighted to be talking to you this morning about Brexit and the implications for employers, because I think he's thoroughly fed up now in advising about furlough and furlough rules. So talking about Brexit is something completely different from Michael. Michael, over to you.
Thank you very much, Robert. So if we could have the first slide, which I think that's it. It's a picture of, was a picture of me before the hostage negotiations, and now I look like this after a successful conclusion. Yes, it's interesting after all these months to be talking about something other than COVID-19 and furlough and what on earth that means, but it's not exactly a fantastically happy topic to get back to generally. It's been going on in the background, of course, for the last 10 months or so, and before that, several years before that. What does it mean for employment law and immigration law? Employers and employees and employment lawyers and politicians share one characteristic. They all think that their idea of what is reasonable is the sun around which the universe revolves, because they are, of course, the most reasonable people in the world, and they are all wrong, because what's been going on since 1973 is that our employment law world has been revolving around the EU, and we've been governed to a significant extent by the treaties and the directives of the European Union and its predecessors, and that is going to come to an end. We know that Brexit has happened, we've left the EU, but we're in this transition period at the moment, as the slide says, so that just for this period of 12 months, nothing much has changed. But what is going to happen next for employment law is significant, but not immediate. Just at the moment, for the next few months, next few weeks really, until the end of this year, pre-existing EU law and current decisions of the Court of Justice of the EU, the Supreme Court of the EU effectively, they still trump domestic law. So if a case came up now and was based to some extent on EU legislation, it would still be governed by what the Court of Justice of the EU says and its previous precedents. Could I have the next slide, please? Thank you. I mean, really, we have already left the EU, as Nicholas was reminding us in a planning meeting for this session. We left it on the 1st of January this year, but we didn't really notice because, as I say, everything has been much the same, apart from the pandemic that popped into our lives shortly after this. But when we get to the 1st of January next year, things really will start to change. I'm going to give you some slides on immigration changes that are directly linked, some of them, to the end of the transition period and the fact that we are out of the EU good and proper from the 1st of January next year. Other immigration changes that might be related to that, but are part of an endless stream of changes to immigration law, right to work law in the UK. But I'm going to start by talking about employment law and what will happen about that right away. As the slide says, from the 1st of January, nothing immediately changes. The legislation that got us into the European Economic Communities in 1973 on the 1st of January, that is being repealed. But the act that does that is preserving all of the pre-existing employment law. I won't talk about any other law, but employment law is being retained just as it is, both in relation to directives and domestic law, but also the way in which those laws have been interpreted over all these years. And what is really going on is that from the 1st of January next year, UK governments will be at liberty to do pretty much whatever they want with employment law in a way that hasn't really been possible since 1973. It just became more obvious as the years went by that a lot of what we do as employment lawyers in the UK has been coming from the EU. It's worth saying that there's plenty of employment law that has nothing whatsoever to do with that. We've had our unfair dismissal law, rights of notice, redundancy pay. There's nothing to do with the EU. In some respects, in terms of anti-discrimination law, we got there first, before the EU came on the scene in terms of equal pay, sex and race discrimination, and so on. Even disability discrimination started as a UK statute, not as something forced on the UK by the EU. However, in the end, virtually all of our anti-discrimination law is governed by the EU, has been governed by the EU, and it's the ultimate interpretation of anti-discrimination law has been in the hands of the Court of Justice of the EU. Now, that won't be the case from the 1st of January. What will be the case is that if someone runs a UK case after the 1st of January and says and bases their case on something that is preserved by the exit legislation, so the law still applies, but it's going to be interpreted by a tribunal, an employment tribunal or a court. For the moment, it's going to be interpreted just as it has been in the past. It won't be affected by some decision that the Court of Justice of the EU comes up with after January. That won't be relevant anymore. But the law that's been preserved in aspect, that will be relevant, but crucially, that's only until the government changes employment law or changes the way in which old cases must be interpreted. So the government will be able to pass new legislation, do whatever it likes, subject to political considerations like will we get re-elected, but politicians in the UK can make whatever laws they want by new acts of parliament and regulations. Or they can pass legislation that says from now on, if a question comes up, for example, to do with the right to paid holiday, this is how the UK court should interpret that case. They should no longer look at those old Court of Justice of the EU cases to do with how you work out someone's holiday pay. Just look at the old case law like this. Now, the government's busy with a few other things at the moment. We thought it was just going to be busy with getting out of the EU, but of course it's busy with the pandemic as well at the moment. And when we've gone properly when we've properly left after the 1st of January and we're not subject to the transitional provisions, they'll still be pretty busy in terms of trade deals with COVID-19, whatever else is going on, and anything else that happens to the country in the meantime. But what can happen after the 1st of January is that politicians in the UK can just form new policies, be elected on them, and implement them without having to worry about what the Court of Justice has to say about anything. And that, I suppose, in a nutshell, is one of the principal reasons why some people wanted to leave the EU in the first place, to give the UK that ultimate decision-making power. The message there is the only change that comes into effect right away is the requirement on voters in the UK to look carefully at what their politicians would like to do to employment law, because they'll have much, much more freedom to make changes than they have had since 1973. So it's not legal advice, but you need to vote with care because you'll get the employment laws that you vote for from now on. Okay, could I have the next slide, please? The right to work. Now, there's already an agreement about how EU citizens are to be dealt with if they're already living in this country, if they're living and working in this country. To date, and up to the end of last year, EU nationals had the right to come and work in the UK, just as UK nationals had the right to go and work in other EU countries. There are associated rights relating to their families. The transition period has just maintained that position, so that if an EU citizen is currently in the UK and is working, they just carry on. The government has, you remember this was all part of Theresa May's negotiations and policies when she was Prime Minister. The government sort of went out and just said that they were going to give EU citizens rights to remain, whatever EU countries did about the UK. And that was meant to be an indication of goodwill. And what is going to happen in the UK as a result of all that is that if someone has been in the UK as an EU national, they have a right to apply for either settled status or pre-settled status, depending on how often and for how long they've been in the UK. And if they're here now, they'll be able to make that application by the 30th of June next year. So there's going to be a rush. A lot of people will have applied already. The consequences of those applications, for example, in relation to settled status, is that if you've got settled status, that's indefinite leave to remain. And so except in very few circumstances, that's a right to be in the UK for life. And so that is one might say, a generous way of going about things, but that is what the UK would hope would happen in other EU countries, of course. So presumably that is why that is a fairly generous proposition. The pre-settled status is essentially for someone who has pretty much stepped into the country, their foot's touched the ground for a day and then they've left again in any 6-month period. They can have a 5-year visa for not being here for very long. So it's a less permanent arrangement. I mentioned there in that slide that if EU nationals, migrant workers who don't apply, are in the country, have been in the country, could apply but don't apply before the 30th of June next year, they may end up being illegal and would have to leave the country straight away. All of these points about how EU nationals are to be treated, I think, are still up in the air. This is a sort of goodwill gesture by the UK government. If all the discussions go horribly wrong, expect these things to be revisited at a later point. Can I have the next slide, please? Where we are going is that if an EU national wants to come to the UK to work next year and beyond, they're just like anyone else from around the world. They'll have to apply for the appropriate visa. It's not my plan in this short talk to give you any details about the different tiers, the different ways in which people can come and work in this country under different sorts of visa. But some employers will be used to tier 2 general worker visa processes, and effectively that is what we're going to have for EU nationals after the 1st of January next year. So if you're thinking about recruiting from the EU, because you have done historically and you're going to next year, you've got to think about making arrangements to get a sponsor license in advance, get some advice so that you're right up to date and you're not starting from scratch halfway through next year when you're desperate to recruit somebody. Could I have the next slide, please? We promised a points-based system. These are magic words that politicians use every so often. Sandeep Tatani, who's my real immigration expert in the team, tells me endlessly that we've had a points-based system for a long time. But if you keep on describing it in a new way, people will think it's new. It's going to be called something slightly different, the skilled worker route or the skilled worker category. If you are thinking about recruiting someone generally from overseas and from the EU in particular next year, you need employment law advice. You need immigration law advice, unless you're an immigration lawyer, which you probably won't be. I mentioned there that the resident labour market test is going to be abolished. That was a way of checking, to some extent, that there was no one in the UK or even in the European Economic Area who could do this job, the job that you want to be filled, rather than the person who's coming in from Singapore, China, USA, or wherever. And the government's also making adjustments about what level of jobs you can use Tier 2 or the skilled worker route for. Effectively, the level is going to go down so that people in a wider range of jobs will be able to come to the UK under this arrangement. Could I have the next slide, please? The same lines, there's been a minimum salary for different jobs. The main limit has been £30,000. It varies from job to job. That's going to go down to £26,500. This points-based system, you can fiddle your points slightly, move them around from one category to another. If there's a shortfall, and there's going to be changes to the way that intra-company transfers work to make things slightly easier. What can I say about immigration law generally after Brexit, proper Brexit? Immigration law is already massively political in every respect. The right to work is hugely political. It's been possible for UK governments to change immigration law and practice on a daily basis via the Home Office. And we all know that, and practitioners in immigration law know that very well. The point about this is that once we're out of the EU properly, and we're not in a transition period any longer, employment law may become more like that. Immigration law can be changed at the drop of a hat without much warning, just by changing guidance on the Home Office website. And employment law could start going to some extent the same way, and it will be subject to, I think, shorter term thinking by politicians of every colour. And so I think that is a trend to look out for in the years after the 1st of January next year. I think I've run out of slides. I may have one more on graduation arrangements. Could I have the next slide, please? Yeah, this is just a minor change. I don't think this has anything to do with the EU particularly. It's just one of the many changes to how immigration right to work rules operate, just making it slightly easier for graduates from overseas to switch from one type of visa to another one without having to do anything drastic like leave the country. They'll be able to slip into paid employment in the UK from that base. I'm not going to say anything else. As I said before, if you need immigration advice and right to work advice, you must get it early, get it soon. You don't want to be finding out about right to work and these rules in June next year when you need someone straight away. Get some advice, come via us. I'll also mention that in the follow-up session we're having in November, there's a big Q&A session, and if you've got your complicated, nasty immigration questions for that stage, you can raise them then. Otherwise, as Rob was saying, we'll try and deal with questions direct in writing and in public if we can't deal with them right away this morning. That's everything I've got to say. Thank you very much.
So thank you for that, Michael. Before I pass over to Nicholas, just a reminder, please, that if you've got any questions, please do keep them coming in using the Q&A and the chat facility with Zoom. I know some of you have already sent us questions ahead, so we do have questions for the Q&A session, but do please keep those questions coming in. Thank you for that, Michael. Nicholas Groffman is our next presenter. He leads our international team, and he's talked about the opportunities that are coming out of Brexit. I think that's a theme that I see lots of clients. They don't just see Brexit as a challenge, they see it as an opportunity. And I think for those of you that do, Nicholas's presentation now will be really interesting to you. So, Nicholas, over to you.
Thank you, Robert. Good morning, everyone. Now, another law firm recently wrote an article on the UK's trade in which they said that it is vital to ensure that the UK's trading relationships continue on the same footing, because in 2018, 49% of the UK's trade was with the EU. Obviously not one single country, but the EU as a bloc. Now that sounds sensible, right? This law firm was saying that because the EU is currently our biggest trading partner, we need to keep things that way. So we're going to come back to that point, but first of all, I want to note in passing that if the EU is still our biggest trading partner in 10 years, then I'll be quite surprised, because the EU accounts for a far smaller percentage of the global economy. It's less than 20%, and that is shrinking all the time, and it has been shrinking steadily since 2000. The second general point, trade deals should not determine where you trade. So a product or a service within an industry sector is known best by the person who is marketing that product. The government doesn't know about the specific product. Now, people who model their business on tax concessions and government plans are losing sight of their core business. Having said that, we would be fools not to examine opportunities that arise from FTAs, free trade agreements, if not because of tariff reductions, but because of the increased engagement and awareness that the buzz around these treaties brings. So in my next 10 minutes or 9 minutes, I'm going to talk about some of our biggest trading partners outside the EU and new free trade agreements. Can I have the first slide, please, the Japan one? Thank you. So here we are, the treaty with Japan. Japan is the third largest economy in the world. Only America and China have more money than Japan. It is embarrassing how little the UK trades with Japan. Our trade volume was just 29 billion. That sounds a lot, but it's actually lower than our trade volume with Switzerland. It is lower than our trade volume with Belgium. The new trade deal with Japan has been finalized in just 10 weeks during a global pandemic. The EU's trade deal with Japan took 4 years to negotiate. UK businesses will now have a competitive edge over other countries dealing with Japan. In particular, SMEs will benefit due to certain provisions in the FTA. And the reason I say that this treaty is better for the UK than the EU one, which we missed out on, is that our treaty with Japan includes industry sectors that are important for us, particularly digital trade and financial services. And there's also a whole lot that relates to the creative industry, which obviously the UK is very strong in, because the FTA includes extra provisions on intellectual property. And overall, 99% of goods between UK and Japan will be tariff-free, which they were not before. Can we have the next slide, please? China. So the US, China, and Switzerland are the only of the UK's top 10 trade partners which are not in the EU. We'll talk about the US shortly, but first of all, China. Again, massively underrepresented in proportion to its size, but trade with China is still very sizable compared to any other country. There are lots of misconceptions about trade with China. The risk is certainly, in my opinion, hugely overstated. Now, I'm a China guy, so I deal with China stuff all the time. But you will not suddenly lose your intellectual property the minute you sign a contract with a Chinese company. You're probably more likely to lose it if you don't sign a contract. Secondly, by trading with China, you are not supporting the crushing of Hong Kong or the persecution of the Uyghurs. And this is something that's been presented to me previously by clients. But those issues are for qualified organizations to tackle. Overwhelming evidence suggests that the interaction and trade between the UK and China improves the relationship between people from those countries. Without it, things would be far worse. And in case anyone accuses me of being a panda hugger, I was part of the gang that successfully petitioned Ofcom to restrict broadcasting by China Central Television. But you have to look at both sides of the picture. The key to dealing with a Chinese counterparty is to do your homework, right? So my experience is that when clients come to me complaining about Chinese villainy, it's nearly always because they behave perhaps more recklessly than they would if they were dealing with a UK company. You think about it for a second and you realize it doesn't make much sense, but it is very common. So do your due diligence. Make sure your contract is easily understood by the Chinese side. Now you'll notice I didn't mention a free trade agreement. Obviously that's because we haven't got one. In 2016, just after the referendum, there was a flurry of activity, mostly on the Chinese side, when they realized they wouldn't have to negotiate with the EU to get a free trade agreement with us. They hated negotiating with the EU. China-UK FTA doesn't really seem likely anymore, or at least not as likely as it did back in 2016. So next slide, please. Here we go. You see the clever picture there. You see what we're getting at. The US-UK trade talks, they were going so well, weren't they? Or at least they seemed to be going well until Joe Biden told Boris Johnson that a trade deal would be blocked if we breached the withdrawal agreement in a way that affected peace in Northern Ireland. Probably a reasonable position for the Democrats to take, and we should take him at his word. There are other bones of contention that could make it very hard to secure a deal with the USA. They hate our new digital sales tax, for example. But the good thing is that trade with the US isn't really dependent on an FTA. It is our biggest trading partner in terms of countries. And in fact, there's a lot about US trade that is more attractive to UK companies than pretty much anywhere else. It's a rule-based economy. The language is the same as ours. They use common law like us, so that's lovely for lawyers. Now, to take an example, this is from recent experience of mine. If I want to set up a company in Spain, what happens? It can take several months for a UK to set up a subsidiary or a branch in Spain. And those months are taken up with quibbling about whether a document is correctly translated, getting the right notary seal and apostille, and so on, all that stuff. Now, I have yet to come across a US state where it took me more than 2 weeks to get the incorporation done. And usually it's a lot quicker than that. Okay, next slide, please. Right, others. So we have lots of free trade agreements, which have not been widely reported, but certainly with the Andean countries, Colombia, Ecuador, Peru, Central America, Chile. We don't yet have one with Brazil, but Brazil's foreign secretary said that they're very interested in a trade deal with us. The Anglosphere. So this is another bunch of countries where it's not just for language reasons, but also traditions and cultural norms, legal systems, Australia, New Zealand, or Canada, where it's easy for British companies to do business. And it's incredible the increase in trade now with those countries since 1516. We do not have trade agreements with any of them yet, but we do have mutual recognition agreements that make standards the same across the countries. And we have discussions ongoing. Yesterday, we just finished the first round with Australia. And then we have India, the second largest investor in the UK economy, Caribbean countries, 3 Middle Eastern countries have signed free trade agreements with us, as have several North African countries and Southern Africa. We have a free trade agreement with South Korea, another very big economy. That doesn't seem to have registered on the radar screen yet in terms of trade, but I'm sure it will. So the last is, of course, the EU. The UK government, and now that's the most politicized of all of these and the most scrutinized. But the UK government has said that a deal needs to be agreed by 15th of October. That's tomorrow. No betting on that one. Switzerland, sorry, I should have mentioned them, big economy in terms of trade with us, and we have a free trade agreement. So let's go back to the original proposition. Should we try and do as suggested by the other law firm and strive to keep our trading relationships exactly as they are proportionally, despite the seismic changes that have taken place over the 5 years? You can see where I'm going with this. I would argue that based on what I've just been talking about, we should actually be completely rejigging our trading relationships. And that puts a lot of pressure on business owners to do their research, but those that have found great opportunities. This is all to take advantage of opportunities offered by the wider world. Thank you.
So thank you, Nicholas, for that overview there of the trading opportunities around the world. So we'll now pass over to Kamal, who is going to talk to you about the health and safety issues coming out of Brexit. Thank you. Over to Kamal.
Many thanks, Robert. Good morning, everyone, and many thanks to Michael and Nicholas before me. For the purposes of my 10 minutes, I'm of course going to be focusing on health and safety regulation as we leave from the 31st of December. But of course, there is a whole plethora of regulatory regimes that will be impacted come 1st of January. But as I say, for the purpose of today, let's just stick to health and safety. So if we move on to my first slide, I think it is fair to say that the EU and the UK together have a global reputation for health and safety law, particularly in highly regulated sectors such as oil and gas, mining and heavy manufacturing. Of course, health and safety in the UK is unique in that although many UK health and safety regulations are based on EU directives, the foundation of UK regulatory regime lies in the Health and Safety at Work Act, which has stood the test of time for more than 45 years now. And health and safety in the workplace involves two different branches of the law, criminal law and civil law. And it's this interplay really that is the area that's notable within the Health and Safety at Work Act. The Act itself is recognised throughout the world as the gold standard and has been responsible for a significant reduction in the number of workplace fatalities and injuries. And indeed, when the EU released the Health and Safety Framework Directive in 1989, requiring employers to evaluate, avoid and reduce workplace risks, it duplicated much of what was already captured in the Health and Safety at Work and regulations that had been made under it. So the UK certainly was at the forefront of robust health and safety management and remains so to this day. The working conditions and expectations that employers have become accustomed to will almost certainly limit the particular political appetite to change UK legislation too much. Certainly, all of the law that's enforced now will remain UK domestic law, yet the status quo is likely to change once this transition period ends on the 31st of December. I think over time, the UK and the EU will go on at least slightly diverging paths, with certain parts of the UK legislation not being implemented in the EU and other parts of the EU law not being followed in the UK, of course. So on my next slide, I'll talk about this, what I call this inevitable divergence. So whilst in the short term, it's likely that there'll be no more than minor differences in UK health and safety laws and those of the 27 remaining EU member states, I think it's important to realise that there'll be separate systems with scope for different emphasis on, for example, risk assessment, control measures, and safety standards, inevitably evolving and altering in different directions over time. Now, this is likely to be more profound for those operating in businesses both in the UK and the EU, and this will inevitably throw up challenges. At present, exactly the same systems apply, but businesses will need to adapt to ensure that they know the requirements in both the UK and the EU. Inevitably, this will result in additional staffing and professional advisory costs, as well as extra time within those businesses and effort to keep on top of the requirements under both systems. So let's take a working example. So let's say I'm a business which manufactures subsea valves and pipeline tools in both Romania and the UK. Currently, I have to follow one set of rules and complete identical paperwork, albeit possibly in different languages. And this is equally true for my health, safety and general regulatory obligations. After the 31st of December, though, it'll be far more burdensome for me as a manufacturer to ensure that nothing is changing in two trading jurisdictions rather than the one that I've been used to. Not to mention the potential extra costs for additional professional advice and to ensure the business is in compliance in two regions rather than one large region. And again, this applies to any reciprocal regulatory obligations imposed under any commercial arrangements. And specifically here, and some of the questions that I've been receiving, I'm specifically thinking about regulations around machinery safety, for example, and what's called CE marking, i.e. when machinery is produced overseas and it's brought into this country, it should follow with a technical file, which is its declaration of conformity against certain standards. Now, moving on to my my next slide, I made mention right at the start that we're seen as this sort of gold standard here in the UK. So with regards to health and safety, the question remains, I think, will the UK's departure dilute the country's gold standard status in health and safety matters? And will we be regulated to silver or bronze on this podium? I think this is largely dependent on the sector in which we operate. And so as the EU increases in size with new members starting to join the union, it may be that in certain critical industries such as oil and gas and offshore renewables, the UK will forge ahead and continue to be regarded as a benchmark setter. Conversely, though, in other areas where the EU is heavily regulated, for example, I'm thinking about pharmaceutical testing and manufacturing, it's possible that the EU will over time steal a march on the UK. And all of this in a round may, of course, have an impact on businesses that seek to operate within the UK itself. So there will inevitably be changes in the composition of the UK workforce following Brexit, and this cuts both ways, as Michael says. On one hand, with inevitably fewer EU nationals working in the UK, it seems obvious that having a greater number of native English speakers will reduce the risk that things will go wrong because of poorer communication, for example, or misunderstandings or lack of clarity within the workplace. On the other hand, if over time the number of experienced EU nationals working in the UK reduces, resulting in a shortage of skilled label, I think there's likely to be a replacement of those inexperienced UK nationals in the workplace. So actually I can see that the greater the shortage of skilled labour in the market may mean the higher risk that things will go wrong within the workplace. And clearly that's likely to have a negative impact on health and safety outcomes for businesses. So what does all this really mean? And on my next and final slide, I've kind of said, in reality, what is this really going to look like? So the UK first applied to join the EU in 1961. This application was vetoed by the French government in 1963. And the second application, of course, was vetoed again by the French in 1967. There was a theme then, but potentially still is. It was only in 1969 that the green light was given to start negotiations for British membership, with talks eventually starting in 1970. And of course, on the 1st of January 1973, we joined what was then the European Economic Community. And when we joined, we were already at the forefront of robust health and safety management. And like I say, it remains so to this day. So the point here is that there was robust regulation pre-EU. And so that's why I think little actually changed in a short term with us finally leaving on the 1st of January with regards to health and safety regulation in the UK. And evidence of this can be found in successive reviews of health and safety regulations, all of which have concluded that on balance, European regulation is positive, it's not burdensome, and there is no evidence of gold plating. And that harks back to the point I made earlier about the UK already having a robust health and safety management system in place. And again, I've made mention there of the Lofsted report. So if we look back to 2011, there was this independent review of health and safety legislation conducted by Professor Lofsted, in which he examined the scope for reducing the burden of health and safety regulation. And he concluded that in general, there is no case for radically altering current health and safety legislation, which, like I say, harks back to the fact that the UK was already ahead of the EU and in this regard. So if we look at currently the position now, the Health and Safety Executive has withdrawn nearly all of their guidance on specific aspects of Brexit and replaced them with simpler nothing changes during the transition period message. In all likelihood, the laws that we have today will probably still have existed without being members of the EU. And it seems unlikely that having set an expectation that people will return home healthy and free from injury, the government or the Health and Safety Executive would seek to dilute the statutory requirements that have been so successful is unlikely. Indeed, I can see a situation where we may have additional regulation to plug some of the gaps that are inevitably created as we have to consider multiple regimes, certainly if businesses trade internationally. So I think I'll leave it there. And Robert, back to you.
Thank you for that, Kamal. We'll now pass over to Georgia Shrine, a senior associate in my commercial team, who will talk to us Brexit and GDPR and data protection.
Good morning. As you can see, my name's Georgia and I work in the commercial team with Robert. And I've got the graveyard slot now to bring to life with GDPR, and that irony is not lost on me. Nonetheless, so I'm going to have a little gallop through GDPR fairly swiftly. I'm here to tell you on slide 1 why we can't entirely ignore GDPR going forward, despite leaving the EU and becoming a third party at the end of the transition period. Why? Why can we not ignore it? Well, one reason is that we have ourselves adapted the GDPR into our own domestic law as the Data Protection Act 2018. And the Data Protection Act is closely drafted and mirrors the GDPR and needs to be read alongside the GDPR. Of course, after the end of the transition period, the government can pass new legislation and we can move away from the DPA as drafted and the GDPR. And it really remains to be seen what approach the UK government develops to tech and data policy. There has been talk that they're wanting to free it up, and that might not go down so well with the EU. The second reason that GDPR cannot be entirely ignored is that the way the GDPR has been drafted means that it covers not only the establishments that are actually located in the EEA. It also, of course, covers third countries, which will be the UK, if they deal with personal data that relates to individuals who are located in the EEA. So we're going to look at what that means very briefly and look at 3 little case studies. Can I have the next slide, please? So the first little case study is about a UK-based company that, for example, has local business, so a local shop selling to normal UK customers and not exporting anything particularly, or a school. And both businesses would collect and process personal data about, say, the children, the customers, staff, suppliers. And it might be quite common, for example, that the email servers or that such personal data that the company is collecting is located in the EEA. So from a GDPR perspective, that would be a transfer of UK personal data out of the UK to the EEA. We have, though, had the reassurance from the UK government that says that that kind of data transfer from the UK to the EEA can continue as it does today. There's no further action required. So if you are a local business that occasionally exports its own UK data into the EEA, it shouldn't be too tricky for you from January onwards. My second little case study, though, gets a bit more complicated. So let's say we have a French business, a French car dealership that sells British cars to customers who are based in France. And they might be transferring personal data from their staff and their customers to, say, the UK-based manufacturer. That data, of course, is personal data. And after the transition period, can such transfers continue as they have been today? Well, that really depends. Yes is the easy answer if we get an adequacy decision. The UK has already applied for an adequacy decision from the EU Commission. That hasn't yet been granted. There is a possibility that it will come through quickly, who knows? Very much depends on the noises coming out, I think, of the UK government and their intention to diverge or not from the GDPR provisions following Brexit or following the end of the transition period. If we get an adequacy decision, then everybody can carry on as normal. If we don't get an adequacy decision, it becomes a little bit more difficult for our French car dealership. It doesn't immediately affect the UK company because you as the UK manufacturer are under no particular duty, but the French car dealership will not be able to send the personal data over to the UK unless it puts additional measures in place. And that will be the same for many other businesses, obviously. So the point is that UK businesses can expect to have requests from any EEA business suppliers and contacts to join them in new agreements standard contractual clauses, binding corporate rules. Similar arrangements will need to be made if those European-based businesses are going to be allowed to export personal data. And the third little case study concerns UK-based businesses who might sell directly to EEA-based customers, for example, a clothing chain or something that supplies direct to customers or via distributors into Europe. They may collect their customers' personal data directly. They may also be dealing with distributors' personal data. Just because it's through a work role doesn't mean it's not your personal data. So that is personal data that the UK business would be controlling, capturing in the EU, and exporting and processing to the UK. And that is going to be most affected at the moment. A UK business can only continue to do that going forward from the 1st of January if they have either an establishment that is based in the EEA, or if they appoint a representative under Article 27 of the GDPR. So that is definitely something that people should be considering if they're regularly trading directly to end customers or distributors or have other contacts within the EEA where they are the primary data controller and capturing the data. So that's really been a very superficial scoop through what the effects of Brexit are going to be immediately on GDPR come the 1st of January. And if there are any questions, I'm very happy to take them in the question answer that follows. Thank you.
Thank you, Georgia. If people thought that they could get away from GDPR under the cover of Brexit, they were sadly mistaken, I'm afraid. But rest assured, no mention of COVID other than that reference earlier to Michael escaping from furloughing. So that completes our presentations this morning. Thank you to Michael, Nicholas, Kamal and Georgia for a real great series of insights into the employment, international health and safety and GDPR issues coming out of Brexit. Before we close off this morning, we've got time for a Q&A session with our panellists. Thank you to those of you who've already sent questions in. If you've got any more that you want to ask during the Q&A, please come forward with them. As I say, we'll either answer them on the webinar this morning, or alternatively, we will follow up in writing on them. So, first question from an anonymous attendee, one from Nicholas Groffman, I think, attendee here who has lost sales to the EU and is looking to the US to make up those sales, and would appreciate some advice, Nicholas, on where to start in the US and what he should be aware of from a legal point of view. Nicholas, what would your thoughts be about that question?
Yes, well, I think it's a good question. It's interesting, and I think this is a trend that people are looking at other markets. So with the US, you're entering an extremely litigious market from a legal point of view. Just statistically, Americans are much more likely to, first of all, obsess about the terms of a contract than people in the EU. Secondly, they're more likely to sue you if they think that you've breached it. So it's very important to do everything right according to laws and regulations and not skip. The second thing is, obviously, you would need, different practical things, the federal tax registration and market research relating to, and I'm sure that that's less of a legal issue, but it's extremely important. And I would imagine the same thing applies to other countries where you might want to set up. Very practically, our observation is that in terms of setting up, things like proximity to where you are personally, you and your business. Are you going to move to the United States, or are you going to stay in the UK? If you stay in the UK, you've got to factor in things like travel time, time zones. So typically we're looking at the East Coast far more than California, unless, of course, what you're selling is skateboards or something that's West Coast specific. And in addition to that, I think it's good to get a comparison once you've pinned down some potential areas where you might want to establish. And we do that a lot, actually, these state-to-state comparisons. So you look at Delaware, New York, Boston, and compare them in terms of flexibility, the ability to sell on your business if you want to, and all the rest of it, infrastructure, some practical things. Last point, don't listen to someone who says you have to set up in Delaware. I don't know why people always advise that. That's good if you're going to be a big list co, but for most people, it's not an appropriate jurisdiction. It's extremely expensive.
Thank you for that, Nicholas. To the attendee who asked the question, well worth following up with Nicholas afterwards. One of our 5 nodes around the world that we work with is the US, and then Nicholas and his team have great connections in the US. So well worth following up with him and getting more advice around that. Next question then from another anonymous attendee. This time a question for Kamal, please. Concerned that they're focusing on getting their business back on track post-COVID and don't necessarily have the time to monitor changes in regulation. What should they be doing at this time to make sure they don't fall foul of health and safety laws, Kamal?
Yeah, thanks, Robert. So there are services, free services out there, of course, such as alerters with regards to keeping people, businesses known of any changes in legislation, and those alerters can be found on the EU's websites. But I would say that A, they're frustrating to use, and B, they're not bespoke to a business. So we've had this come up a number of times with our clients, of course, and it's something that we can do in-house in terms of this audit service to ensure that any updates that are required from a health and safety perspective and regulatory perspective generally, we can do those in-house. So we will have a service whereby we collate all the various changes in law and legislation relating to a particular sector, and then of course provide that advice that's required to the businesses that are requiring. But like I say, there are if anyone was to Google legislation updater, you'll find a number of services out there. But I'll just put a question mark as to whether A, they're bespoke enough for your business, and B, whether they're actually going to do what you require them to do, i.e. advise on the legislation and how it impacts your business. So, but yeah, certainly that's something that we can look into as well, Robert.
Thank you, Kamal. Hopefully that answers the attendee's question. But again, I think worth following up with you and your team as to the specifics. A question then for you, Georgia, from Sarah Fricker, who asks, first of all, 2 parts of the question. First of all, do we think that the UK will get an adequacy decision on GDPR before the 31st December? Now that might be yes, no, maybe, or anything in between, I guess, Georgia. You're still on mute.
Must unmute myself. I'm sorry about that. So I would hedge a bet that we are unlikely to get an adequacy decision before the 31st of December, partly because we're not entirely a third country until then due to the transition arrangements, and partly also because of the noises that are coming out at the moment that seem to indicate that the UK intends to move away from the GDPR and the UK Data Protection Act. This idea of freeing up data flow and having freer tech is great, but it's not in this sort of in keeping with the GDPR close monitoring of data flow. So I doubt they're going to be in a big hurry to give us an adequacy at the moment. Where do you find a representative? There are many, many people supplying services online, but I think it is not the only solution. We are looking at as well what the alternative arrangements could be if you wanted to establish a small subsidiary within the EEA and maybe use it for a variety of purposes, including GDPR compliance. Alternatively, if you do go down the route of appointing a representative, it's certainly worth checking out the different services available and really checking what those subscriptions cover. So I would advise that mainly.
Thanks, Georgia. Hopefully that answered Sarah's 2 questions there. I think the reference to what we're looking to do as a firm with data protection is actually quite interesting, and Sarah or other attendees may be interested in our data protection service that we're going to be offering come the new year as part of our HCR Flex service. So there's more of that to come, but in essence we'll be able to offer DPO services and similar, Georgia, won't we? So there's more of that to come. Okay, and the next question also for you, Georgia, this time from another anonymous attendee. My data is held in the EU, the attendee says, and asks the question, do they need to change anything after Brexit?
Well, if you are a UK-based company and you are sending your UK data onto servers that are located in the EU, that at the moment is fine. It won't need to change after the 1st of January either. The reason for that mainly is that our Data Protection Act is so closely linked to the GDPR that sending data into the EEA means it complies with the GDPR and therefore complies with the Data Protection Act at the moment. So it's fine.
Thank you for that, Georgia. Yeah, there's no more GDPR questions for you. Michael, a final question of the morning from you from Vanessa Howarth. Thank you, Vanessa, for your question. The question around European Works Councils and will they encompass the UK after Brexit?
The answer to that one is we don't know what will happen generally with European Works Councils other than if they're governed by EU law and that's the way they have been operating, then they won't be governed, that won't work in the UK anymore. To the extent that there's a European Works Council at a company in the UK at the moment, it may, as things stand, lose its effectively its statutory basis on the 31st of December. And there isn't any news about what happens to it after that. There's also an issue about where the Works Council is based, what jurisdiction governs the law. So I think the point is, the short answer is don't know. It'll be about the 2075th thing that'll be dealt with on someone's shopping list when other things are being dealt with if we ever make a general deal with the EU. That's my estimate.
We'll skip over shopping lists and deals, Michael, and potential timescales. But thank you for that. That actually now finishes off the questions from all our attendees. So thank you very much to the panel for their contributions on those. And thank you to everybody who attended the webinar. We hope you found it interesting and of use to you in your businesses. We'll be following up the webinar this morning with a short questionnaire, which will be coming to you by email. We very much value feedback, so please do take time to complete the questionnaire. And then in a few days' time, we'll be following up with a recording of the webinar for you, and also you'll have written answers to the questions. But what I would say there is, as always, we're not a clock-ticking firm. If you want advice on any of the issues raised in this morning's webinar or any wider issues, do not hesitate to pick up the phone to me or to any of the panelists, and they'll be happy to talk to you about the issues we've raised or any wider issues. More than happy to do that. The last thing then I need to do is advise you of our next Brexit event, which is on the 19th of November. That will be an interactive session, which will be live Q&A with group discussions. So I'll be earning my fee as chairman for that particular event. But those interactive webinars, you've not done one with us yet, really good, great opportunity to ask questions and also hear what other people are concerned about and what other people are finding out. And already it's very clear that despite the challenges of COVID and the focus of people on that, actually people are now starting to focus on Brexit and get ready. So I'm sure the event on the 19th of November will be as much interest as today's. And we look forward to seeing and welcoming many of you to that event then. And in the meantime, thank you again for attending, and thank you to our panelists for their presentations and Q&A feedback. Thank you very much.